Hi, welcome to our channel of IGNOU audiobooks, Indira Gandhi National Open University, School of Law, SOL, Postgraduate Diploma in Intellectual Property Rights, PGDIPR. MIP 105 Copyright and Related Rights. Block 1 Basics of Copyright. Unit 4 Exceptions and Limitations. 4.1 Introduction. In this unit, we will look into the context in which use of a copyrighted work without specific authorization of the owner will not be considered as an infringement of the copyright in that work. The copyright law provides exclusive rights to authors over their original works. This is to encourage creativity, since rights ensure that unauthorized persons cannot misappropriate the gains from a work. That would be motivation for further creation. At the same time, literary, dramatic, musical and artistic works are also part of the culture of a society. They are also to be part of education and learning. Therefore, fair access to these works has to be ensured. This is done through by allowing certain uses without specific authorization of the copyright owner. These uses are referred to as exceptions and limitations to the copyrights. In certain jurisdictions such as in the United States of America, they are called fair uses. Indian law generally uses the term fair dealing. The provisions, of course, are very elaborate. 4.2 Objectives. After studying this unit, you will be able to assess the context in which you can use a copyrighted work without special authorization from the owner of the copyright therein, and appreciate the case laws related to it. 4.3 Exceptions and Limitations. Section 52 of the Copyright Act declares certain acts not to be infringements of the rights granted by the Act. It says that a fair dealing with any work, not being a computer program, for the purposes of private or personal use, including research and criticism or review, shall not be an infringement. This allows most of the genuine, non-commercial, personal uses including research purposes. It also permits fair dealing with a work for the reporting of current events and current affairs, including the reporting of a lecture delivered in public. This facilitates the work of journalists. It would extend to both print media and electronic media. However, the fair dealing exemption does not apply to computer programs, though they are also literary works. The term fair dealing is not defined in the Act. The general approach is that it should not be a substantial reproduction of a work and it should not be for commercial purposes. Substantiality is both a question of quantity and quality. The following observations of Lord Denning in Hubbard vs. Vesper, 1972, are illuminating. Quote, One must consider first the number of quotations and extracts. Are they altogether too long to be fair? Then consider the use made of them. If they are used as a basis for comment, criticism or review, that may be fair dealing. If they are used to convey the same information as the author for a rival purpose, that may be unfair. In regard to computer programs, the law provides specific exceptions. These include the making of copies or adaptation of a computer program by the lawful possessor of a copy of the program in order to utilize the computer program for the purpose for which it was supplied, or to make backup copies purely as a temporary protection against loss, destruction or damage. It also permits reverse engineering and decompilation of a program so as to enable operating the program with another independently created program, provided the needed information is not otherwise readily available. It also permits the making of copies or adaptation of a computer program from a personally legally obtained copy for non-commercial personal use. The storing of any work in any electronic medium for purposes of private or personal use, or for research or criticism or review, or for reporting of current events and current affairs, including the incidental storage of any computer program which is not itself an infringing copy for the same purpose, will also not be considered an infringement. To facilitate internet communications, the Act provides very specific exceptions for the transient or incidental storage of a work purely in the technical process of electronic transmission or communication to the public, and also for the transient or incidental storage of a work for the purpose of providing electronic links, access or integration. However, where the access or integration has been expressly prohibited by the right holder, this exception will not apply. The law also provides for a takedown notice. That is, if the copyright owner sends a written notice to the person responsible for the storage of the copy that such transient or incidental storage is an infringement, then the person responsible for facilitating the access shall stop the access. But such stoppage will be for a maximum of 21 days, within which the copyright owner should obtain necessary court orders. Otherwise, the access provider can resume the facility. Reproduction of any work for the purposes of judicial proceedings or parliamentary work will not be an infringement. Earlier this was limited to literary, dramatic and musical works only. The reproduction of a literary, dramatic, musical or artistic work by a teacher or a pupil in the course of instruction, or as part of the questions to be answered in an examination or in answers to such questions. Other exemptions for educational purposes include the publication in a collection mainly composed of non-copyright matter, bona fide intended for the use of educational institution, provided that not more than 2 such passages from works by the same author are published by the same publisher during any period of 5 years, and the performance in the course of activities of an educational institution of a literary, dramatic or musical work by the staff and students of the institutions, or a cinematograph, film or a sound recording if the audience is limited to such staff and students, they, parents and guardians of the students and persons directly connected with the activities of the institution. Other permitted uses include the following: the performance of a literary, dramatic, or musical work by an amateur club or society, if the performance is given to a non-paying audience, or for the benefit of a religious institution. The reproduction in a newspaper, magazine or other periodical of an article on current economic, political, social or religious topics. The publication in a newspaper, magazine or other periodical of a report of a lecture delivered in public. The making or publishing of a painting, drawing, engraving or photograph of a work of architecture or the display of a work of architecture. The performance of a literary, dramatic or musical work or the communication to the public of such work or of a sound recording in the course of any bona fide religious ceremony, including a marriage procession and other social festivities associated with a marriage or an official ceremony. The Act also provides that the storing of a work in any medium by electronic means by a non-commercial public library, for preservation if the library already possesses a non-digital copy of the work, will not be an infringement. Another exception is in regard to the making of a 3-dimensional object from a 2-dimensional artistic work, such as technical drawing, for the purposes of industrial application of any purely functional part of a useful device. The Indian Act has a special provision with regard to sound recordings known popularly as version recording. The Act allows the making of sound recordings in respect of any literary, dramatic or musical work, if sound recordings of that work have been made by or with the license or consent of the owner of the right in the work, and the person making the sound recordings has given a notice of his intention to make the sound recordings, has provided copies of all covers or labels with which the sound recordings are to be sold, and royalties in respect of all such sound recordings to be made by him at the rate fixed by the Copyright Board in this behalf. There are few attendant conditions also to this provision to ensure that it is not misused and that the copyright owner is not at a loss. This exception, after the 2012 amendment, has been moved to the category of statutory licenses. 68. An important exception added by the 2012 amendments was the one for persons with disability. The adaptation, reproduction, issue of copies or communication to the public of any work in any accessible format by any person to facilitate persons with disability to access to works, including sharing with any person with disability of such accessible format for private or personal use, educational purpose or research, will not be an infringement. Any organization working for the benefit of the persons with disabilities, in case the normal format prevent the enjoyment of such works by such persons, can also do so. This exception is on condition that the copies in the accessible format shall be made available to the persons with disabilities on a non-profit basis. The person or organization who makes such formats available can, however, recover the cost of production. The organization making such copies accessible to the persons with disabilities should ensure that the copies of works in such accessible format are used only by persons with disabilities, and that those copies do not enter ordinary channels of business. The Act also provides that the importation of copies of any literary or artistic works, such as labels, company logos or promotional or explanatory material, that is purely incidental to other goods or products being imported lawfully, is exempted. The provisions in the Act ensures that the needs of private, personal uses, education, research, news reporting and uses for the purposes of the legislatures and judiciary are permitted without any hindrance. The deciding criterion is that the use should be fair. Copyright is limited by the national laws. This is a kind of territorial limitation. but the TRIPS norm of national treatment enables foreigners to enjoy the same rights as a national, subject, of course, to the two countries being members of the TRIPS agreement. However, in the matter of duration of copyright, the law of the country of origin of the work prevails. Case law. A case where the issue of fair dealing came up and was examined exhaustively is the Chancellor Masters and Scholars of the University of Oxford versus Narendra Publishing House and Oz, in the Delhi High Court in the year 2008 pronounced. On the 17th of September 2008, LA. 982,312,005, 5,112,006 and 647 2006 in CS, OS, 16,561. 2005. The court looked into case laws in the USA, UK and in India where the scope and extent of fair use in the US and fair dealing in India and UK were examined. This examination throws much light on the concept of exceptions and limitations and, therefore, the relevant extracts from the judgment are reproduced below. The next question is whether such copying will be covered under the fair use exemption provided under Section 52 of the Act, assuming that the plaintiffs prima facie have established a copyright claim. Relevant parts of Section 52 of the Act are extracted below. The doctrine of fair use or fair dealing is an integral part of copyright law. It permits reproduction of the copyrighted work or use in a manner which, but for the exception carved out, would have amounted to infringement of the copyright. In a seminal article published in 1990, Judge Pierre N. Laval wrote, "The doctrine of fair use need not be so mysterious or dependent on intuitive judgments. Fair use should be perceived not as a disorderly basket of exceptions to the rules of copyright, nor as a departure from the principles governing that body of law, but rather as a rational, integral part of copyright, whose observance is necessary to achieve the objectives of that law. Fair use should not be considered a bizarre, occasionally tolerated departure from the grand conception of the copyright monopoly. To the contrary, it is a necessary part of the overall design. Briefly stated, the use must be of a character that serves the copyright objective of stimulating productive thought and public instruction without excessively diminishing the incentives for creativity, toward a fair use standard. 103. Harv. L. Reverend. 1105, 1990. One of the earliest decisions to deal with the doctrine of fair use was Folsom et al. Versus Mass et al. 9F Cas. 342, 1841 U.S. App, where the U.S. Supreme Court laid down the following. In short, we must often, in deciding questions of this sort, look to the nature and objects of the selections made, the quantity and value of the materials used, and the degree in which the use may prejudice the sale, or diminish the profits, or supersede the objects of the original work. Many mixed ingredients enter into the discussion of such questions. In some cases, a considerable portion of the materials of the original work may be fused, if I may use such an expression, into another work, so as to be undistinguishable in the mass of the latter, which has other professed and obvious objects, and cannot fairly be treated as a piracy. Or they may be inserted as a sort of distinct and mosaic work into the general texture of the second work, and constitute the peculiar excellence thereof, and then it may be a clear piracy. The breadth of the fair use doctrine use was put to test in the U.S. case of Harper and Row vs. Nation Enterprises 471 U.S. 539, 1985. Harper had contracted to publish President Ford's memoirs. In exchange for $25,000, Harper allowed Time magazine to extract 7,500-word passage from the book, which dealt with the pardon to President Nixon. The editor of Nation magazine wrote an article relying on an unauthorized version of the memoir, which reproduced 300 to 400 words of the passage contracted to the Time magazine. The article in Nation appeared before the article in Times, and the latter refused to pay up the balance money to Harper. Harper brought an action for infringement of copyright, and Nation put up a fair use defense. The court noted that the four factors identified by Congress, 17 U.S.C. 107, as especially relevant in determining whether the use was fair were: 1. The purpose and character of the use, 2. The nature of the copyrighted work, 3. The substantiality of the portion used in relation to the copyrighted work as a whole, 4. The effect on the potential market for or value of the copyrighted work, and proceeded to test the facts on each of these grounds. In its analysis, the court applied much emphasis on the commercial character of the defendant's use and its implication on the potential market of the copyrighted work. While doing so, it recalled the observations made in Sony Corp. of America versus Universal City Studios, Inc., 464 U.S. 417, 1984, that every commercial use of copyrighted material is presumptively an unfair exploitation of the monopoly privilege that belongs to the owner of the copyright. The court, while fortifying the commercial-non-commercial divide, held that the fourth factor was the single most important factor while determining fair use. It is, however, important to note the dissenting opinion of Justice Brennan in this regard. He regarded the majority opinion as conferring monopoly on historical facts and not merely on the exception. He cautioned that this approach would prove counterproductive to the very end of granting copyright protection and observed that, in my judgment, the court's fair use analysis has fallen to the temptation to find copyright violation based on a minimal use of literary form in order to provide compensation for the appropriation of information from a work of history. The failure to distinguish between information and literary form permeates every aspect of the court's fair use analysis and leads the court to the wrong result in this case. Application of the statutorily prescribed analysis with attention to the distinction between information and literary form leads to a straightforward finding of fair use. The contours of the fair use standard shifted somewhat with the decision in Campbell vs. Acuff Rose Music, 510 U.S. 569, 1994. The Supreme Court unanimously upheld the claim of the defendants that their parody to the plaintiff's song, "Oh, Pretty Woman," was covered by the fair use exception. It was uncontested that the defendant's song amounted infringement, but for the fair use exception, the court held that all the traditional four factors employed to reach a conclusion of fair use are to be treated together, not in isolation, and no undue preference can be given to any one of them. In relation to the first factor, it was held that court must look into the nature of the use, i.e. whether it was for educational purposes or for review or criticism. The central inquiry, according to the court, is to see if the work merely supersedes and supplants the original work or instead adds something new, with a further purpose or different character, altering the first with new expression, meaning, or message, in other words, whether and to what extent the new work is transformative. The court borrowed the latter expression from Judge Pierre Laval. Transformative works, the court held, have a greater chance of falling within the fair use defense, and such works thus lie at the heart of the fair use doctrine's guarantee of breathing space within the confines of copyright. If one may put it differently, the question to be addressed would be, is there a value addition which alters the original work in a not insignificant measure? The second factor, which evaluates the nature of the copyrighted work, is intended to find out if the work actually merits copyright. That is, whether copyright law was intended, at its core, to cover such works. However, the court cautioned that this factor is not likely to help much in separating the fair use sheep from the infringing goats, in cases where the subsequent work is transformative. The third factor, which deals with the extent of copying, does not entail that the reproduction of the entire work would militate against the finding of fair use. There could be cases where the copying could be substantial and the court finds fair use. At the same time, there could be cases where the copying, though insubstantial, could be held as infringement. Lastly, the court observed that the fourth factor, where the market harm to the copyrighted work had to be assessed, could not be the sole determinative factor. The courts have to consider not only the extent of market harm caused by the particular actions of the alleged infringer, but also whether unrestricted and widespread conduct of the sort engaged in by the defendant would result in a substantially adverse impact on the potential market. The court went on to hold that the defendant's use was covered by the doctrine of fair use and did not amount to infringement. The court's holding in Campbell has been followed in SunTrust Bank vs. Houghton Mifflin, 268 F3D 1257, 11th Cir.2001, vacating the injunction on The Wind Done Gone, a fictional work based on Margaret Mitchell's Gone with the Wind. Bill Graham Archives vs. Dolling Kindersley, 2006 U.S. App. Lexus 11593, holding that reproduction of images appearing in posters and tickets in a coffee table biography fall within the fair use exception, and very recently in Peter Letteries and Associates vs. World Institute of Scientology. Enterprises, DC Docket No. 04-61178 CVPCH, July 8, 2008. In the United Kingdom, in Hubbard vs. Wasper, 1972, 2, W, L, R, 389, the court while dealing with the question of what amounts to fair use, observed as follows. It is impossible to define what is fair dealing. It must be a question of degree. You must consider first the number and extent of the quotations and extracts. Are they altogether too many and too long to be fair? Then you must consider the use made of them. If they are used as a basis for comment, criticism, or review, that may be a fair dealing. If they are used to convey the same information as the author, for a rival purpose, that may be unfair. Next, you must consider the proportions. To take long extracts and attach short comments may be unfair. But short extracts, and long comments may be fair. Other considerations may come to mind also. But, after all is said and done, it must be a matter of impression. As with fair comment in the law of libel, so with fair dealing in the law of copyright. The tribunal of fact must decide. Indian law too, in relation to copyright infringement, is interesting. The Supreme Court in R.G. Anand had to adjudicate whether the film produced by the defendant had in any manner infringed the copyright held by the plaintiff in his play. The court, after referring to a number of authorities on the subject, observed that the same idea might be developed in different ways, and if the defendant's work is nothing but a colorable imitation of the plaintiff's work, then it would amount to infringement. It set out the following as the test for determining infringement. One of the surest and the safest tests to determine whether or not there has been a violation of copyright is to see if the reader, spectator, or the viewer, after having read or seen both the works, is clearly of the opinion and gets an unmistakable impression that the subsequent work appears to be a copy of the original. One remarkably, the court, presciently in its judgment, propounded a principle resembling the transformative work doctrine developed in the United States. Much later, it held that, where the theme is the same but is presented and treated differently so that the subsequent work becomes a completely new work, no question of violation of copyright arises. In Ramaya, the Andhra Pradesh High Court had to consider whether a guide book prepared to help students understand and study a text called Girija Kalyanam amounted to infringement. The court took note of the fact that the guide consisted of 3 portions, the first of which gave meanings to the text. The second portion contained annotations and illustrations of the meanings, and the third portion consisted of probable questions and answers. The court distinguished the facts from that in Blackwood and Sons vs. and Parasuraman, where the infringing work merely eliminated certain passages from the origin A1 work and retained the essential part of the narration in substantial form. Since the guide was found to be much more than a mere replication of the earlier work, incorporating questions and answers, analysis, etc., the injunction was refused. In M. Foster, the court had to determine whether a guide published for the novel, A Passage to India, violated the copyright in the original novel. Here, again, the court noted that there was no verbatim reproduction of the entire novel. The guide was divided into different portions, which consisted of an introduction to the characters, the life and philosophy of M. Foster, a brief introduction to the works of M. Foster, and of course an abridged version of the novel, though not chronological. The court observed, referring to Kartar Singh Giani vs. Lada Singh, AIR 1934 La 777, that in the guise of copyright law the plaintiff cannot ask the courts to close all the avenues of research, scholarship, and all frontiers of human knowledge. The court found that the guide did not constitute an infringement and therefore did not go into the question of fair dealing. In Romesh Chaudhary, too, the facts involved publication of guide books to books published by the university in accordance with its syllabi. The court found that the guides were not colorable imitations of the university publications and amounted to criticism and review of those books. It also observed that since the university in their syllabus published these books for the students, the matter had gone into the hands of the students and no copyrights on the strict sense of the term remained with the complainant. The question of fair dealing came up for consideration in Sivak Chandran vs. Amini Amma 1996, 16, PTC 610. The defendants had published a play Nangal, A Communistaki, that was intended to be a critique of a famous play Nangal, Enna Communistaki. The court referred to Hubbard vs. Vosper and R.G. Anand, and concluded that the play was meant to be a critique and therefore constituted fair dealing under Section 52. It observed that the latter work was not market competitor to the prior work, and by itself constituted a literary work with some amount of originality. Moreover, the court held that the nature of the work, that is to criticize the social structures in Kerala, by itself meant that certain sequences events and incidents would be common to both the prior and the subsequent work, and that the latter was not meant to imitate the former. Injunction was, therefore, denied. Copyright law is premised on the promotion of creativity through sufficient protection. On the other hand, various exemptions and doctrines in copyright law, whether statutorily embedded or judicially innovated, recognize the equally compelling need to promote creative activity and ensure that the privileges granted by copyright do not stifle dissemination of information. Two doctrines that could immediately be summoned are the ideal expression dichotomy and the doctrine of fair use or fair dealing. Public interest in the free flow of information is ensured through the ideal expression dichotomy, which ensures that no copyright is granted in ideas, facts, or information. This creates a public pool of information and idea from which everyone can draw. At the same time, as Judge Level observes, all creativity is in part derivative, in that no creativity is completely original. Each advance stands on building blocks fashioned by prior thinkers. Bernard Shaw expressed it by saying that Shakespeare was a tall man, but he, Shaw, was taller as he stood on Shakespeare's shoulders. Judge Level further observed that most important areas of intellectual creativity like philosophy, literature and sciences are referential and require continuous re-examination of existing theses. The doctrine of fair use then legitimizes the reproduction of a copyrightable work. Coupled with a limited copyright term, it guarantees not only a public pool of ideas and information, but also a vibrant public domain in expression, from which an individual can draw as well as replenish. Fair use provisions then must be interpreted so as to strike a balance between the exclusive rights granted to the copyright holder and the often competing interest of enriching the public domain. Section 52 therefore cannot be interpreted to stifle creativity and, at the same time, must discourage blatant plagiarism. It, therefore, must receive a liberal construction in harmony with the objectives of copyright law. Section 52 of the Act only details the broad heads, use under which would not amount to infringement. Resort must, therefore, be made to the principles enunciated by the courts to identify fair use. One crucial test of the four-factor test, as developed by the American courts, is the transformative character of the use. The courts should, in cases like the present, ask whether the purpose served by the subsequent or infringing work is substantially different, or is the same, from the purpose served by the prior work. The subsequent work must be different in character. It must not be a mere substitute, in that it is not sufficient that only superficial changes are made, the basic character remaining the same, to be called transformative. This determination, according to the court, is closely knit with the other three factors, and therefore central to the determination of fair use. If the work is transformative, then it might not matter that the copying is whole or substantial. Again, if it is transformative, it may not act as a market substitute and consequently will not affect the market share of the prior work. In the present case, this court has considered the plaintiff's textbooks as well as the defendant works. The following aspects stand out. A. The plaintiff's textbooks, so far as they contain the theory portions, have not been copied. B. The plaintiff's books do not contain the steps or process aiding the solutions or answers to the questions, problems in each chapter. The learner is expected, on the basis of the text and the theory, to apply his mind and solve such problems. C. The defendant's copies do not contain the text and the theory portions analyzing the problems. D. The defendant's copies contain the questions as well as answers, which are found in the plaintiff's textbooks. A. The defendants provide the problem-solving, step-by-step method to arrive at answers to the questions. A careful analysis of the above would show that whereas the plaintiff's texts do not contain or describe the step-by-step process of arriving at solutions, answers, the defendant's books provide them. The defendant's books do not contain the theoretical or explanatory content they are present in the plaintiff's textbooks. The use of questions and answers by the defendants, who provide the step-by-step process of reasoning, is for a different purpose. Though to a purist or one who delights in intellectual pursuits, such works may be distasteful, even offensive, there is no gainsaying that they neither pretend to be textbooks nor reproduce all that are contained in them. They are designed to cater to a category of student weak in their understanding of the subject. The purpose and manner of use of the questions found in the plaintiff's textbooks by the defendants is thus different. Additionally, in their books, missing in the plaintiff's works are the steps or process of problem solving. Thus, the defendant's works can be said to be transformative, amounting to Rev. IEW under Section 52(1) (e) of the Act. Here, the term review has to be interpreted in the context. The plaintiff's claim to copyright is a premised the work being a literary 1. The review or commentary of a part of such mathematical work too would have to be seen in the background of this claim. Review, according to the Shorter Oxford Dictionary, 5th edition, means view, inspect or examine a second time or again. In the context of a mathematical 1. work, a review could involve re-examination or a treatise on the subject. In that sense, the defendants revisiting the questions and assisting the students to solve. Then, by providing the step-by-step reasoning prima facie amounts to a review, thus falling within the fair dealing provision of Section 52(1)(e) of the Act. 4.4 Summary. In this unit, we have seen that there are many uses of a copyrighted work which do not require any specific authorization of the copyright owner. Mostly they should be fair dealings, which really do not deprive the copyright owner of his rightful economic returns. A fair dealing with works for personal uses without any commercial purposes are generally exempt. Uses for legislative and judicial purposes also are exempt. Thank you for watching. We will see you in the next video with the next chapter.